All right, welcome back everyone to another deep dive. This time, we're looking at a case fresh from the Supreme Court, Dawson v. Steager. It all boils down to whether West Virginia can give a tax break to their retired law enforcement officers without giving the same treatment to federal law enforcement who retire in West Virginia.
You got it.
The Supreme Court ultimately decided that West Virginia's law was discriminatory, and they reversed the state Supreme Court's decision. So let's unpack all of that.
Sounds good.
So first, what exactly is at the heart of this case?
Well, we've got a West Virginia law that exempts state and local law enforcement officers' pensions from state income tax, but that doesn't apply to federal law enforcement.
Okay.
And this all came to a head when James Dawson, a retired U.S. Marshal, found himself paying state income taxes on his federal pension in West Virginia. He argued this was unfair, citing a federal law, 4 U.S.C. Section 111.
So Dawson is saying, look, I worked in law enforcement just like those state officers. I retired in West Virginia just like them. So why should my pension be treated differently when it comes to state taxes?
Precisely. And this federal law he's citing, Section 111, basically aims to stop states from discriminating against federal employees just because their pay comes from the federal government.
Makes sense. So how did this whole thing play out in the courts?
Well, initially, a West Virginia trial court actually sided with Dawson. They looked at the job responsibilities of a U.S. Marshal compared to these specific state officers who were getting the tax break.
Okay.
And they decided there weren't any really big differences. But then the case went up to the West Virginia Supreme Court of Appeals, and they reversed the lower court's ruling.
Uh-oh.
They argued that the state's exemption was quite narrow and only intended to help a small group of state retirees, not to harm federal ones. They didn't think it was meant to be discriminatory.
I see. But then the case made its way to the U.S. Supreme Court. What do they make of all this?
The U.S. Supreme Court ultimately agreed with Mr. Dawson, reversing the West Virginia Supreme Court of Appeals, and they leaned heavily on a principle that was established in a previous case, Davis v. Michigan Department of Treasury.
Okay, so another case about taxes and government employees.
Yes, in Davis, the court made it clear that states can't treat their own retired employees better than retired federal employees for tax purposes unless there's a really good reason for the difference.
Interesting. So they're saying equal treatment for retired state and federal employees unless there's a real justification for treating them differently.
Exactly. And this isn't just some general principle. It's actually rooted in federal law. That's Section 111 we talked about earlier. It lets states tax federal employees, but with a big caveat, they can't discriminate just because the income is coming from the federal government.
Got it. So how did West Virginia try to defend their law in front of the Supreme Court?
Well, they put forward a few arguments. One of them was that their tax exemption didn't apply to all state employees, just a small group of specific law enforcement retirees.
So they were saying, hey, it's not like we're giving a huge tax break to all our state employees. It's just this small specific group, so it shouldn't be a big deal.
Right. Their argument was that this limited scope means it shouldn't be seen as interfering with the federal government's operations in any significant way. But the Supreme Court didn't buy that argument.
So just because it only affects a small number of people doesn't make discrimination okay?
That's exactly what the court said. They emphasized that Section 111 doesn't say anything about discriminatory state taxes being okay if they only affect a limited number of people.
Okay.
They really hammered home the point that any state tax that treats federal employees worse than state employees just because of where their pay comes from is a problem, no matter how many people it impacts. They even cited Davis, that earlier case, where they refused to add any implied exceptions to Section 111.
Interesting. So no wiggle room in the law, no matter how narrow or specific the tax break seems to be.
Exactly. And while the limited nature of the exemption might affect the scope of what the federal government could do in response, it doesn't give the state a free pass to have a discriminatory law on the books in the first place.
Makes sense. Did West Virginia try any other arguments to justify their law?
They did. Another one they put forward was about intent. They argued they weren't actually trying to disadvantage federal retirees. They just wanted to give a benefit to their state law enforcement retirees.
So they were saying, hey, our hearts are in the right place. We're not trying to be unfair to federal employees. We just want to support our state employees.
Right, but the Supreme Court shot that down pretty quickly. They emphasized that when it comes to Section 111, the state's motivations behind the tax law don't actually matter. The focus is on the law's effect, on whether it actually treats people who work for the federal government less favorably than it treats people who work for the state.
So it's not about the thought, it's about the action, about whether the law actually results in unequal treatment.
Exactly. The court pointed back to a bunch of previous cases to reinforce this. Davis, Barker v. Kansas, and Phillips Chemical Co. v. Dumas Independent School Dist. All of these cases focused on whether the state tax actually resulted in discrimination, regardless of what the state said its intentions were.
Okay, so we've talked about the law and the state's arguments, but what about the actual people involved? Did the court consider whether Mr. Dawson, the retired U.S. Marshal, and those state law enforcement officers who got the tax break were really in similar situations?
That's a key question in any discrimination case. Were they similarly situated?
Right, because if their jobs were totally different, maybe different tax treatment wouldn't be discriminatory.
Exactly. And West Virginia argued that retired U.S. Marshals and the specific group of state law enforcement officers getting the tax exemption weren't actually similarly situated for various reasons beyond just their everyday job duties.
Interesting. But how did the Supreme Court respond to that argument?
The court focused on how West Virginia's law itself defines the group getting the favorable treatment. In this case, the law specifically gives a tax break to retirement plans for people who worked in those specific state law enforcement jobs. So, a federal retiree who is similarly situated would be someone who had a similar job.
Right, so it's all about comparing apples to apples.
And remember, the trial court already found that Mr. Dawson's duties as a U.S. Marshal were basically the same as those of the state officers who were getting the exemption. The West Virginia Supreme Court didn't even try to argue against that finding.
So both the trial court and the Supreme Court agreed. Same job, same treatment.
Exactly. And the Supreme Court emphasized that you have to compare the federal retirees to the specific group of state retirees who are getting the tax break, not to all state retirees in general. This lines up with how they've decided similar cases before, like Phillips and Davis.
Got it. So they're not just looking at all federal employees versus all state employees. They're looking at the specific groups who are being treated differently. Did West Virginia try any other arguments?
They did. They suggested that maybe the exemption was related to differences in how generous the pensions were. Maybe, they argued, the state pensions weren't as generous as the federal ones.
So their argument is, maybe it looks like we're discriminating based on where someone worked, but really it's about making things more fair because our pensions aren't as good.
Right. But the court wasn't convinced by that either. The actual language of West Virginia's law didn't mention anything about comparing pension generosity. It just favored retirees from those particular state law enforcement jobs and excluded people in similar federal jobs.
So the court's saying if you're going to give a tax break because of pension differences, you have to actually write it that way in the law.
That's right. And the court again referenced the Davis case, saying that if a state really wanted to account for different pension amounts, they would base the tax break on the actual amount of benefits someone receives, not on where those benefits came from.
Got it. So you can't just say after the fact, oh, we were really thinking about pension amounts when the law itself doesn't say that.
Right. The court was clear. West Virginia's law discriminates based on the source of the retirement income, plain and simple. And that violates federal law.
Okay, so we've really broken down the court's reasoning in this case. Now, for our listeners, let's shift gears a bit and put on our 10th chair hats. Let's imagine you're actually sitting on the Supreme Court hearing this case. What would your perspective be?
Well, if I were that 10th justice, I'd start by acknowledging that states do have a lot of power when it comes to taxes.
Sure, states need to be able to raise revenue to fund their operations.
Exactly. But that power isn't absolute. It's limited by the Constitution, especially the Supremacy Clause, which basically says federal law trumps state law when they conflict. And it's also limited by federal statutes like this Section 111 we've been discussing.
Right. The Constitution and federal law set boundaries for what states can do.
And in this case, West Virginia's law pretty clearly crossed that boundary. It created a specific benefit for retired state law enforcement officers and explicitly excluded retired federal officers who had basically the same jobs. To me, allowing this kind of discrimination would set a really bad precedent. It could encourage states to try to undermine the financial well-being of federal employees who live and work in their states just by giving special tax breaks to their own state employees in similar fields.
Right. So it could create a kind of uneven playing field where states are essentially incentivized to favor their own employees over federal employees.
And the argument that this discrimination only affected a small number of people just doesn't hold water for me. Discrimination is discrimination, regardless of scale. Plus, the state tried to argue that the tax break was really about pension amounts, but the law itself doesn't say that.
So the justification doesn't really match up with the actual language of the law.
Exactly, and that makes their argument pretty weak. So to me, the Supreme Court absolutely made the right call in striking down this West Virginia law. It reaffirms the principle that people who dedicate themselves to public service, whether at the state or federal level, deserve to be treated fairly and equally when it comes to taxes, especially when their job responsibilities are essentially the same.
That's a really thoughtful 10th chair perspective, and it really highlights the bigger issues at stake. So, to wrap up, the Supreme Court's decision in Dawson v. Steager serves as a powerful reminder that states can't discriminate against people just because their retirement income comes from the federal government instead of the state, especially when those people had comparable jobs.
You got it. And it underscores how important the actual wording of tax laws is. If states want to create exemptions or benefits, they need to do it in a way that's based on legitimate, non-discriminatory factors, and they can't just try to justify discriminatory treatment after the fact with arguments that aren't reflected in the law itself.
Absolutely. And this ruling also shines a light on the protections that exist for federal employees against this kind of discriminatory state tax treatment, thanks to federal law.
Right, that Section 111 we've been talking about is a crucial safeguard.
Now, the case is headed back down to the West Virginia courts to sort out the appropriate remedy for Mr. Dawson. But this decision could have broader implications as well. It makes you wonder, are there other state tax laws out there that might unintentionally be creating similar discriminatory situations?
It definitely raises that question. States might need to take another look at their tax codes to make sure they're in line with this ruling.
Right. And this case really highlights the delicate balance between a state's power to tax and the need to protect the federal government and its employees from discrimination.
It's a fascinating area of law, and this decision will likely have a ripple effect in other states as well. It'll be interesting to see how things unfold.
Indeed. It leaves us with a lot to ponder. Thanks for joining us for this deep dive into Dawson v. Steager. Until next time, keep those legal minds engaged.